Hello and welcome to Idea to IPO. I'm Jennifer Stowell. Idea to IPO has been 2010. At that time, we had no members and no events on our calendar. At this stage, we have over 100,000 members among all of our meetup groups all around the world. We have organized, promoted, and produced more than 2,567 events. By any standard, by any measure, we are the most active, most prolific We organize venture capital panels, legal workshops, networking events, and more. These days, we are 100% online. We hold an event nearly every day of the week. Check out our schedule at idea2ipo.com. Our featured speaker today is Roger Royse, one of the top venture capital attorneys in Silicon Valley, and he is passionate about helping entrepreneurs succeed. Ladies and gentlemen, Roger Royse. Roger, take it away.
Okay, thanks very much, Jennifer. Appreciate that introduction. And thank you, Rob. Thank you, Idea to IPO, for having me here today. So my name is Roger Royse. I'm a partner with Haynes and Boone. And I'm here to talk to you today about how to split the pie, raise money, and reward contributors. So give me a second here. So a couple of housekeeping items before we get going. So number one, I want to let you know that this is being recorded, and I am going to be using slides, and you'll be getting slides you'll be getting slides and the link to the recording after this is over by email. So don't worry about asking me about slides. You'll get them if you really want them. Secondly, I'd like you to know that we've opened up the chat to everybody. So you can go ahead and if you got something to pitch, if you got a LinkedIn link you want to post, like I just did, a Twitter feed, something like that, go ahead, use the chat function. You can chat to everybody here. Now, you know, we used to do these events live. And when we were live, you could meet people, you could exchange business cards. Rob used to let people come up and talk a little bit about their companies. We can't do that on Zoom very easily, but we can use the chat feature for folks to talk with each other. So go ahead, you are wide open. So can you hear me? Because I got a note here on chat that you lost voice. So chat to me if you can hear me okay, and if you can see me okay. And all right, okay, you can hear me. Can you see me? People say that I've got a face made for radio, so I got to ask if you can see me. Okay, all good, great, thank you, thanks. Excellent use of the chat function. Awesome. I know we got a smart group here tonight, but I want to find out how smart. So we're going to take a little poll here, and go ahead and take the poll while I'm talking. I'd like to know who's in the audience. Do we have startup entrepreneurs, people from established companies, investors, service providers, academics, governments, government personnel, press, media, or that pesky other category? While I'm doing that, I want to let you know that I'm streaming this live to Facebook tonight. You're going to find this video, by the way, on my personal YouTube channel. Feel free to check it out there and subscribe. Subscribe to my YouTube channel. You can see all of these. You'll also have an opportunity to subscribe to my firm newsletter when this is over from Haynes and Boone, where I'm a partner in the Palo Alto office. Okay, with 80% of the vote in, we have 70% of you are startup entrepreneurs, and the only other category that goes above 10% is others. So it looks like we got a lot of startup entrepreneurs here tonight. That's awesome. I'm going to use that information in my presentation. So let's do another poll. Now that we can do this on Zoom, we do this all over the world. And I know we've got people here from far, far away and at odd times of the hour. So let me know where you're from. Just go ahead and post it onto the poll. So far, most people are from Silicon Valley. Okay, that's good. Silicon Valley, other North America, we've got Asia. Wow, 14% from Asia, 8% Western Europe. That's pretty good. Normally, we don't get a lot of people from Western Europe because of the time, but we're doing pretty good tonight. So this must be a topic that people are interested in. I want to remind folks again that here's my LinkedIn, and here's a hashtag for Twitter if you're tweeting. All right, so I'm going to go ahead and close the polling in a few seconds here. We've got 74% of the vote. It's 2/3 of you are from North America, 1/3 of you are from Silicon Valley, 12% to Asia, and then there's a lot of other. I wonder where that other is. You know, India probably. I didn't mention India in my poll. Okay, but largely a North American audience with some of you from outside the country. That's okay, because the things I'm going to talk about here tonight are going to be relevant to you wherever you are in the world, a lot of it, especially if you plan on doing business here in the United States, especially if you plan on coming to Silicon Valley, but even if you don't. All righty, now comes the most difficult part of the evening. I'm going to need your help on chat because this is where I share my screen. So you should be seeing my screen now. So somebody chat me and tell me whether you're seeing my screen. Now I'm going to go ahead and put this on. There we go. All right, we all good? 15 chats, sharing successful. Awesome. We're off to a good start. We're off and running. Okay, so as I said, my name is Roger Royse. I'm a partner with the law firm of Haynes and Boone. I'm resident in the Palo Alto office in the heart of Silicon Valley. We are right into the content in 7 minutes. I think that's a new record, actually. We're getting good at this. Just want you to know that even though I'm going to be talking a lot about the law, it's one of my personality defects, is that I'm a lawyer. This is not legal advice. This is just me talking about the law. So what we're talking about here today, again, is how to split this pie, how to divide up a company. I think most of you out there, if you're startup entrepreneurs, and most of you are, I know I took a poll, I think then you probably have co-founders. Most startup companies do. Certainly most successful ones do. Think about all the big names, the big successful companies you can think of. Most of them had co-founders. Even Microsoft had co-founders, right? They almost all had co-founders. And that raises this issue, well, how do we divide up the equity among the co-founders? It's one of the big things we'll talk about here tonight. But it's not just co-founders that get equity. It's not just the people that found companies that you have to be concerned about. There are lots of stakeholders in any startup company. There are not only the founders, you've got service providers, meaning advisors, meaning employees, meaning consultants, people like that, even some of your outside service personnel like me, consultants. And then of course there are investors. I'm going to touch on all three of these topics here tonight in my 57 slides, which is about 1 per minute. I don't think I'll get through all of them. We're going to go until the top of the hour, 7 o'clock, and then I'm going to take questions. Now, if you have questions as we go along, go ahead and type them into the Q&A box, and I'll go ahead and answer your questions at the end of the presentation from until 8, from 8 until 8:30 tonight. So we're going to go from 7 till 8, then from 8 till 8:30, I'm going to go ahead and answer questions. So let's start with the founders. I think that's a good place to start. How do we divide up the founders' equity? Right? That is the first question. And oftentimes the way this comes up with me, because I'm a startup lawyer and I work with a lot of companies right at the very beginning, is 2 or 3 people will come into my office, they'll sit down and they'll say, we want to form a company because we've got this brilliant idea, or maybe they'll meet in a bar and scratch it out on a napkin. I've had that happen more times than you would believe. And the first question you're going to have to, you're going to be asked and answered is, how are we going to split up the equity? And that's number one, but that's not the only question. We're going to talk about vesting. I'll talk more about that in a little bit. We're talking about what sort of formula there is for dividing up that equity. Are we going to do it equally? Are we going to divide it up through some subjective determination? Subjective usually means whoever's the best negotiator and can pound their fist on the table the loudest. Or are we going to use some sort of formula? And I'm going to talk about several of them tonight. Okay, can everybody hear me? I know somebody says they're having trouble with the audio. All right, so let's keep going then. So how many founders should you have? I think is the first question I want to get to. So like I said, most successful companies that I've seen, yeah, it depends, a good answer, but most successful companies I've seen have had more than one founder. My view is that every once in a while you can have a one founder company that does really well, but that person better, if you're a tech company, you got to be technical and you better be really good with business and you better have domain expertise in whatever industry that you're in. It's oftentimes very rare to find a person who has all of those qualities. I'm not saying it's impossible, but if you're a company that's going to scale, it's going to be rare. So I don't think one is usually the right answer. Two founders is probably what I see most often. I don't think that's a great answer either, and I'll tell you why. It's because of deadlock. I've seen deadlock so many times, and that is definitely a deal killer. That is a company killer. If you've got deadlock, you're done. You know, there's just nothing you can really do about that short of solving the deadlock, and you just don't want to be in that position. Investors certainly don't want you there. By the way, the worst possible combination, I'm about to say something controversial and get in trouble yet again this week. I've been doing it all week. The worst possible combination I've seen for a two founder team is boyfriend, girlfriend. I have never seen that work, by the way, or at least not so far. All right. So just, just a little data point for you, just so you know, I've seen that go bad every time so far. Three is actually a good number of founders because you're not going to have deadlock, but there's always somebody that's going to feel like there's two founders ganging up on one. So you just need to be aware of that. So if you're going to be in the three founder scenario, be with the majority on that if you want to stick around. 4 again is deadlock potential, and 5 is just too many. If you got 5 founders, you're going to be losing a founder within the first year. I promise, I guarantee. Or you're going to have to exit in the first year. 5 is too many. So it's a tough decision, but something you ought to think about up front. Not everybody has to be a founder, but more importantly, not everybody has to be equal, right? So you could have 4 founders, but not have them equal to avoid this deadlock scenario. I want to use a case in point in this founder's first decision. Now that you know you've got co-founders as to how to split up that equity. Zipcar was a 50-50 deal, 2 founders. Co-founder 1 built the startup, crafted its business plan, and cold called their customers. Co-founder 2 did not contribute quite so much. Not so much, as we would say here in California. The company did well, as you know, but you go Google it, you can read all about it. They don't think they did as well as they could have done, all right? And in fact, co-founder 1 has been pretty vocal about this over the years, how unpleasant this was and what a big mistake this was. So I'm going to tell you how to avoid that mistake, but Zipcar was the exception. I see the scenario all the time, and usually it ends really, really badly, all right? Usually it ends with the company not getting any money and just dissolving. This is a case where it ended with the company doing well, but having to go through a lot of pain to get there. So how might we split up equity? Okay, the most common way that founders and companies, you're asking for suggestions, here's some. The most common way is equal split. Now, I'm here to tell you what a bad idea that is, but let me give you the counterpoint as to why an equal split might not be a bad idea. It is the most common. Number one, your exit is 10 years away. It just is. I mean, not always. I mean, I had a company that went from 0 to $200 million exit in 6 months. So it happens. And they had 5 founders. So they broke and they didn't have a 409A. They broke every rule in my book and they all got rich. So, that's the exception that proves my rule. For most companies, an exit is a long ways away. You're going to go through several rounds of financing, several ups and downs. People are going to come, people are going to go. That being true, do you really want to try to hardwire what the percentages are 10 years from now that people are going to get on your exit? I mean, wouldn't you rather instead put something in place which can be equal now, but has some safety valves in place, some mechanisms to adjust that equity down the road as circumstances change? Because all that real work is going to happen in the future. How do we do that? Well, the easy way and the traditional wisdom is through vesting restrictions and through additional stock grants. I'm going to talk more about vesting before we're finished here tonight, but vesting is the number one way that you're going to control this. That's how you're going to adjust. What vesting means is you earn into your shares. So for example, if you've been granted 50, if you start out with 50% of a company, but you have 5-year vesting, that means you're going to earn that 50% at a rate of 10% a year over 5 years. The legal mechanism for making that happen is that the company has a repurchase right at cost. We don't need to get into that now. Now, the reason that this has actually become a really good way, because I know what you're thinking. You're thinking, well, geez, Royce, you just told me it's 10 years before I exit, but I got 5-year vesting. So I'm going to be fully vested, 5 years before I exit. How are you going to adjust for me then? The real answer is that the investors are going to make you unvest, right? They're going to make you unvest. Nobody vests over 4 years anymore. Nobody vests over 3 years anymore. People vest over 3 or 4 years, then they take in some investment and they start the clock running all over again. And they keep unvesting again and again, as long as there's investors. So that might sound bad to you, but the good thing is that it is a mechanism for adjusting equity, because if somebody is not performing, they can lose their unvested shares unless they come back to the table and renegotiate. Secondly, we can always do additional stock grants. We can always do additional stock grants. Happens all the time. Somebody performing better, doing more, we just grant them additional stock down the road. We just have to have enough dry powder. We have to have the ability to do those grants. We have to take a hard look at the cap table. We'll look at a cap table here tonight and see exactly how we can make that happen without destroying your ability to raise money. Okay, another model, the dynamic split model. All right, here is the general concept. A fixed split model is what I just described. We're gonna give you equity based on your anticipated contributions or equal. Dynamic says, look, your relative percentage in this company is going to change over time based on your actual contributions. We're going to measure your inputs, time you spend working, the cash you put in, the IP you contribute, you let me use your parents' garage, you get credit for that, all of that stuff. Sales, you're instrumental in sales. Those are the inputs. And based on that, we come up with a formula. And this formula changes every day because people are putting in more time every day or less time. And we just measure the relative inputs of each participant as compared to every other founder in the company. And not just founders, it's basically designed for larger teams. Now, this is a system that has not gotten mainstream adoption, I would say. It's got some popularity. There's a professor at Harvard Business School who thinks it's a great idea. He's done a whole study on this. He's talked about the fact that companies that use these equal splits tend to have lower valuations at exit than companies that do a dynamic split or something like this. If you want to see more about this, you can go to the website slicingpie.com. Mike Moyer, who runs that website, he's got several books on the topic, and he has a little calculator that you can take a look at. So, and there are also some templates that you can look at. There are lots of legal issues around this and tax issues. You're still issuing securities. We have to deal with that. You may have tax impacts every time somebody vests or every time somebody's percentage ownership increases. There are issues there to deal with, for sure. It's complicated. And thirdly, you have to have a very disciplined team that's actually going to go to the trouble of entering their inputs in order to get the outputs. But this is a system, and people who really love process like this system. So I've done it a few times myself, actually a lot of times. Here's another system. I'm going to go through a few of them. Similar to this, the Founders Pie calculator, created by Frank Demler, he's at Carnegie Mellon, basically is a formula system where you divide the founder's value add into 5 categories. And this is really the idea that, look, how about instead of deciding on the equity split, why don't we just get together and decide on a process or a system or a formula or a method for figuring out what the split is? And that's what the Founders Pie calculator is. And then you have to sit down and figure out what everybody's contribution is. Here's an example. You got founder 1 and founder 2. We decided that founder 1 had more to do with the idea than founder 2, so he gets, some points for that. business plan, that was all founder one, but you know, founder two knows a little bit more about this sector than founder one. So you sit down, and if you can agree to these 5 points, you can come up with the pool. This differs from the dynamic split, and the dynamic split is going to do this on an ongoing basis. This does it once at the beginning. The problem with it, as we suggested, is that the work is yet to happen, right? The work is yet to happen. So you need to have mechanisms, vesting and additional stock, to adjust for what happens down the road. Here's the grunt fund, or the slicing pie formula. You can see that it's the same thing. It's a formula. This is their Excel sheet you can download off their website, which just values each of these inputs. Time, cash, equipment, supplies, facilities, intellectual property, commissions, and the grunts are the workers, the founders are the employees, and you add up the dollar value of everything. And by the way, in this calculator, each one of these inputs has a different weight. Cash is worth 4 times what time is. So if you put in $10 worth of cash and $10 worth of time, you get $40 worth of credit for the cash and $10 for the time. And then it summarizes it all. I guess this is the daily detail, where you figure out what each of these inputs are worth, what they're worth. Take a look at it if you're interested. And of course, we have the best method of all. I've saved the best for last when it comes to figuring out founder equity, and that is the Royse subjective method. That's where we just see which way the wind is blowing, right? And I go through this a lot. And what I'd rather do, I think that this is such a complex subjective determination that we really need to just sit down and talk this through. And what I'd like to understand, if I'm going to, I guess, weigh in on this issue, is number one, are you people full-time or part-time? Number two, are you technical or non-technical? If it's a tech company, you know, sorry to disappoint a lot of you, but technical people are worth more in a tech company as founders, because you can get way more out of them as founders than you can as consultants, has been my experience. Non-technical people tend to be more easily replaceable. At least that's the way it's viewed when splitting up equity. Industry expertise, I keep saying how important that is, size and stage of the business. How much cash compensation are you taking out? If you're taking cash out, your equity's got to go down. You can't have both. Other contributions. And then again, I'll say it again, we need to have those relief valves, the vesting restrictions, a big option pool, maybe some phantom shares, something to adjust if we don't get it right under the Royse subjective method. Now that's for founders. For later hires, there are several formulas for figuring out how to give stock or give equity to later hires. Paul Graham has a formula, which basically, I won't go through the math because I'm a lawyer, I don't do math, but the formula is basically how much can the employee improve the outcome, right? So if your employee that you're hiring is going to get you more than 3%, you know, in your exit, well, then they're worth 3%, you know, of the equity of the company. It's that sort of thing, kind of the way you'd hire a broker. You know, I'll pay you 6% if you can get me, you know, 7% increase in price. So that's the Paul Graham formula. It's expressed with more complexity than that on his website, but that's the basic idea. The Fred Wilson formula, which is even more complicated. By the way, these are all these people listed here are venture capitalists. So so they're gods, and we have to treat everything they say as pearls of wisdom, which I am. The Paul Wilson formula, and they do this every day for a living. Option pool formula, this is a formula for determining how big the option pool is, which basically determines how much equity you have to give to your later hires. And he just says, well, what's the cumulative salary between your 2 rounds, A and B, we'll say, divided by your post-money valuation, that's the amount of the increase in the option pool you're going to need. Kind of makes sense, right? The idea is your salaries are going to equal the equity. It's rough justice, but hey, it's a system. And then there's one fellow here who actually did some statistical analysis. What a concept, data, you know, not just opinion. And just found out from job postings as to, you know, how much equity later hires typically get. Here's the chart. You can Google this. You can find the backup behind the data, but you can see that as the company gets further and further down the line and hires more people, the less equity it grants to its later hires. Kind of makes sense. Let's move on to advisors. Because after you're finished putting your founding team in place, one of the first things you ought to be doing is thinking about who your advisors are going to be. Who do you want as your advisors? Now, what are advisors? Let's be clear, they are not directors, they're not officers, they're not consultants, they're not employees. They're there for a very specific purpose. They're going to advise you on some very specific aspect of your company, your industry, or your market, or sometimes your technology, something like that. There are advisors that will help you access capital markets. That means raise money. There are advisors that will advise you on technology risk. There are advisors that will get you into companies so you can make those sales. There are advisors that do all this stuff. So how do you get those people? Who are they? What do you do with them? How do you reward them? What do we do with advisors? First of all, I think it's a rare company that should not have an advisor. I mean, even with your founding team, there's stuff you're just not going to be able to do as effectively as you could with an advisor. Again, there's exceptions that prove my rules, but I really think that you will do well considering adding advisors. Just kind of think, where are the holes? Where could you use help? Where's someone going to help you? Raising money is a big one. A lot of companies hire advisors to help them with that. Be very careful about that, by the way. I hear VCs say all the time, they don't like working with finders. So instead, if you're going to have an advisor that helps you with that, you want somebody who's just got good, solid personal relationships in the community that you want to get into. Same with sales advisors, right? You want someone with those good, solid personal relationships. Now, question number one, what are you going to give the advisor? Here's a rule of thumb. I start with 1/4% of equity of the company. That's where we start. And then we go up or down from there, depending on a couple of things, mostly how valuable the advisor is. I've got a company now that we're negotiating with an A-list Hollywood celebrity to be an advisor, and his starting gambit was 4%. It's 4 or 5% equity. That's off the charts for an advisor. But he's a big name. If he puts his name on this company, we're all going to Hollywood. We'll all be hanging out sipping tequila with supermodels in some Beverly Hills disco. But is that worth 4%? I don't know. I think not. So we probably won't do the deal. On the other hand, I have a lot of advisors that get 0.1% because their contribution is not going to be quite that much to the company. Again, if we follow the formula, we'll just ask, is that 4% going to get us more than 4% in uptick? Probably. Anyway, 1/4%, you move up or down from there. Now, if you go online, a friend of mine over at the Founders Institute has come up with a system called the FAST model. And if you Google it, you can find the agreement, and it is an advisor agreement. It's been downloaded hundreds of thousands of times, and attached to the agreement is this little matrix, this little template. And on this template, you can figure out where you are in terms of stage, in terms of how much contribution the advisor is going to provide. And based on that template, you'll come up with a number, and it'll be between 0.1 and 1% usually, right? So I like the FAST model. It's a system. It seems to be pretty close. So I would encourage you to consult that if you're bringing on advisors. Now, how do you keep the advisors' feet to the fire and nose to the grindstone? Again, vesting. Remember vesting? They earn into that equity that they've been granted, and they earn it over time. But the advisor's only going to be around for a little while, maybe a couple of years before their part is done, right? You need them to get you this big sale. They get the sale and then they're gone, right? So 4-year vesting that we often see in the Valley for founders, or 3-year, doesn't really work for an advisor. So it doesn't work so usually an advisor is going to have 2-year vesting. Let me just start there. Now it can toggle up or down depending on who he is and what he's doing, he or she. But let's start at 2 years, because they ought to be in and out in 2 years in most cases. But that's still not quite good enough, because it's not that you want their time. You don't need their time. What you need is a milestone. You need a deliverable, right? So not only will there be time-based vesting, there'll be milestone and deliverable-based vesting. In other words, you said you get me 6 customers or 6, introductions in this industry. You vest when, you get the 6, that sort of thing. Almost every advisor agreement is going to have milestone and deliverable vesting now, right? You earn your shares by meeting these deliverables, almost always. So keep that in mind. You'll be sorry if you don't. One last thing I'll say about vesting for advisors. So now all the advisors in the audience, I know, all hate me for telling you that, but you're all going to love me for what I'm about to tell you next. Advisors will almost always fully vest on change of control of the company. And the reason why is that the acquirer of the company, they don't need your advisor. I don't care how good they are or how big a celebrity they are. They don't need them. They're not going to take them. They're not going to continue their vesting schedule. So they're going to cash out whatever vested shares they have at that time. So almost always advisors will have vesting on change of control, so they get full vesting. So if the company gets sold, they're fully vested and they get the full benefit of their equity grant. Now, when I say equity, what do I mean by that? What do you actually give an advisor? Almost always options, right? For tax reasons, almost always options, sometimes stock. Let's talk a little bit about what the difference is, because I'm going to talk more about this as we go through. Now, I see some of you have questions as we're going along. Type your questions into the Q&A box, not into the chat box. That's just for people to scold me. The Q&A box is where you type your questions. And I will get to those at the top of the hour, and we'll do a half hour on those. Now, an option is a right to purchase stock, right? It's a right to purchase stock at a certain price. That price is the fair market value, typically at the date that the option is granted. So if the option goes up in value, you get the benefit of that appreciation. Options are not that exercised that often. Exercise means you've actually purchased the option shares. They're not exercised that option. What usually happens is that the company gets sold and the option gets cashed out. That spread gets paid to the option holder. So it's a way for somebody without having to come out of pocket for any cash at all to participate in the upside of a business. It's a great deal. The difference between an NSO and an ISO, an ISO is an incentive stock option. It's a creature of statute. It is tax favored. With an NSO, when somebody does exercise, if they ever do, they're going to be taxed on the difference between the value of the stock and the exercise price. With an ISO, they are not taxed on the value of the stock and the exercise price of the stock. They're not taxed until they actually sell the stock that they purchased with the ISO. And then if they've met two holding periods, 2 years from grant, 1 year from exercise, they get capital gains treatment. And capital gains are at 20% federal right now, plus 3.8% net investment income tax. So it's a great deal. That's an ISO. It's subject to alternative minimum tax, so that takes away a lot of the greatness of the deal. But for a lot of people, it's still a pretty good deal. That's the difference between an NSO and an ISO. Now, there's this thing in the Valley called extensions or extended NSOs, and it's getting more and more popular all the time. And I, for one, hate it. And let me tell you what it is. So the way an option works, it says, look, this option is granted to you to keep you in the company, to keep you around, to make you stick around until we have a sale to contribute. So you're going to invest over time. But if you leave, right, you don't get your unvested option. And you're only going to have a certain period of time, between 30 and 90 days, typically, depending on if it's an ISO or not, to exercise that option and buy your vested shares. And if that 90 days expires and you haven't bought your shares, the option expires and you don't get the shares. That's a typical option. It's right in every option grant. Well, what happens? The person leaves and the company says, you know, gee, they really did contribute to the company. I hate to see you lose your option. We're going to agree to extend. Not only that, it means I have to pay you less severance, and the optionee is asking for it. So we extend and say, look, you don't have to exercise in 90 days. You can exercise within the next year. There's a way to do that without causing tax problems. There's a way to do that to cause major tax problems. So, you know, see me about that. But let's assume you've gotten good advice and you've extended the option for a year. I still don't like it. You know why? Because now we've got additional option overhang. And what I mean by that is it increases this number called fully diluted capitalization. Because when a VC invests in your company, they're going to invest based on the assumption that every option outstanding has been exercised. So these options that we just assumed would gradually be recycled and expire as people left, and you replace that person with another person, another option, it doesn't expire. It's still out there in your fully diluted capitalization. Not only does that increase your fully diluted capitalization and reduces your price per share, so that you're giving away more stock to the VC when they invest, it also creates some uncertainty here as to exactly how much stock do you have outstanding. With the typical option plan, we got history, we got data, we can kind of guess as to what's going to be exercised. But once you start extending options, it makes that guess a lot harder to do. So I don't like them, but I do them because companies insist on it. Even the VCs let you get away with it these days. But I'll just let you know that that option, no pun intended, is out there. Restricted stock is a grant of stock that is subject to the same vesting restrictions an option would be. So the restricted stock is actually issued. So it's not a right to buy stock. The stock gets issued. Either gets granted or it gets sold to somebody. If it's granted, you've got a stock tax consequence because the value of the stock is typically compensatory compensation income. If it's purchased, then someone has to pay for it. I'll tell you how to do that in a minute. The interesting thing about restricted stock, though, is that it's restricted, subject to vesting. You have to earn into it. And if you leave, it gets repurchased at cost. We do that a lot. I like to do that for founder level people. I like to do that. My rule of thumb on this is if someone's, and not everybody's, but mine, is that if you're going to give somebody more than 1% of your company, they ought to just be buying stock, right? Now, why would they want to do that? Why would they want stock and not an option? And suppose they don't care about voting rights. They don't have enough stock to sway the vote anyway. The reason they do that with an option, that option gets cashed out when you sell the company. You have ordinary income taxed at 37%. It's going to go up to 39.6 if Joe Biden gets his way, federal plus state, which is going to go up to 16% if our legislature gets its way. So lots of taxes on cashing out an option, plus Social Security taxes, plus net investment income taxes. With a, when you sell the stock rather, with restricted stock, however, you sell the stock, you pay capital gains, 20% rate plus California or plus state, wherever you are. I forget, some of you are not from California. Well, if you're unlucky enough to be in California, you got to pay California taxes when you sell that stock. But anyway, it's a lot less rate federally on restricted stock than options. That's why people would like them. Phantom plan units. A phantom plan unit is basically, it's kind of like, let's forget this fiction that someone's going to have equity ownership in a company, because you just told me, Royse, that nobody ever exercises options. They just hang around until you sell and then they get cashed out. So why don't we just do away with that stack of paper this is about this thick and just give them a bonus? Just say, look, if you're here and we sell the company, we give you X dollars. And X dollars might be X dollar per unit that you own, and each unit's the same as common stock, a share of stock. That's a phantom plan unit. I do that a lot. Okay, and it's not a bad option, not a bad alternative to an option. Again, it's ordinary income when it gets paid, subject to tax, subject to payroll taxes, all of that stuff. RSUs, restricted stock units. I only talk about enough to say that they're not really appropriate for early stage startups. You see them, why not? Because what it is, it's a promise to grant stock to you in the future. As you vest, you are granted stock. When that happens, you have a taxable impact, a taxable event. If you've got illiquid private company stock, how are you going to pay your tax, right? It works really well with publicly held companies. And that's why big companies that you've all heard about have RSUs, because people get the stock and they can go sell them, or maybe they can do a forward sale, or they can leverage them or borrow against them and they can pay their tax. Can't do it. So I rarely use RSUs, not in early stage companies anyway. All right. Now, remember what I said, I'm not going to spend a lot of time on this because I'm only on slide 18 of my 57 slides. In fact, all I'm going to say is there is a way that you can buy stock, get your holding period running for capital gains treatment, and not have to come out of pocket. You can give a promissory note to the company. Trouble is, someday you're going to have to repay that note. If the company's bankrupt, you still have to repay that note. Sometimes we can limit your liability on that. Just put a pin on that. That's a little arcane. Who should vest? I'll say a few more things about vesting before we kind of speed this up. Everybody should vest. Everyone who provides services to the company should vest. That is just orthodoxy now. In Silicon Valley, nobody argues with me over that. How long should they vest? I see founders vest over 3 or 4 years, but remember what I said, that's a fiction. You're going to invest over the life of your company because you're going to have to unvest every time an investor comes into your company. They're going to make you do that. By the way, you know why 4-year vesting is sort of a standard in all the documents? There was a time when companies would start and go public in 4 years. They all said it was going to be next year, but as a practical matter, it was 4 years. So 4-year vesting made perfect sense. That's how long you needed to keep somebody around until you could exit your company. Companies don't go public in 4 years anymore, unless you do a SPAC. Maybe we'll do a whole presentation on SPACs someday. But other than SPACs, companies are going to hang out for a lot longer, and they're probably not going to go public. They're probably going to get sold. So that vesting, is going to change. Now, nobody is willing to stomach 7 or 8 year vesting in their agreements. I've never seen it. Never seen it. But I've also hardly ever seen anybody only do 4-year vesting. It's always longer. So they always re-up, just plan on it. Acceleration is the idea that if the company gets sold before you're finished vesting, you get cashed out for all of your shares. Your unvested shares are vested on the date of that change of control, that sale of the company, and you get cashed out. You did your part, you stuck around, you got the company sold, you should get full credit for it. Rarely is that granted by itself. If it's granted by itself, that's called a single trigger. Same with termination without cause. What if we got 3 founders and you told me 2 always gangs up on 1? What if they kick me out for no reason? That's not my fault. I should get all of my vesting, right? That's another single trigger. I don't see that very often. VCs won't let you get away with it. They might let you get away with a double trigger if you're senior enough and important enough to the company. Double trigger means both those things happen. You just been made redundant by the acquisition. In other words, company gets sold, and within 6 months you get fired. Then you get additional or maybe full vesting. That's a double trigger. That's something, if you're a founder, you should negotiate for and ask for. All right, I'm not going to talk about fire the founder. The VC's view of vesting. Most of the companies I deal with are looking for venture capital. Last year was $150 billion in US venture capital. It was a record year. This year is going to be another huge year. There is a tremendous amount of venture capital money floating around out there. By the way, think about this for a minute. We're in a historic time in history. There's record amounts of venture, and I do fund formation. I'm telling you, we're forming a lot of funds. A lot of people are starting new funds to do this. There's PPP money. There's tremendous amounts of government money floating around, and it's not all going into game stock options, right? It's out there in the ether. There's crowdfunding. The rules on crowdfunding are about to be liberalized in about 2 weeks. You're going to be able to raise $5 million instead of $1 million through a Reg CF offering. That's a crowdfunding offering, unless the Biden regulatory freeze postpones that, but it won't be forever. So there's a tremendous amount of money out there. So what are and angel money? I haven't even mentioned that. So what are these VCs? Everybody still wants VCs because that gives you a path to liquidity, right? They know the investment bankers, they know their buddies at the golf course who are going to do the next round. People still want venture money. Plus they bring to you expertise, knowledge, and again, some very good paths to liquidity. So what are they going to require? As I said, they're going to require unvesting. And they're also going to want you to somewhat match their fund life. And we do a whole presentation on how to negotiate with VCs. The only point I want to make here is they're going to want you to be invested as long as they're in this company, and they're going to be in this company until you exit, until their fund life expires, which could be 7 to 10 years off. Class F super voting stock. I just want to mention it because I know you're thinking about it. And this is a scenario where, well, look, it's kind of like I deal with this, God, every week now, it seems. The idea is, all those founders are created equal, but some of us are a little more equal than others. And, I'm like Zuckerberg. I should have more votes. I should have 10 votes for every vote that guy has, especially these people that are coming along later. So we create a special class F, super voting stock that has additional rights. So Zuckerberg can control the company forever and ever. You can get away with that if you're Facebook or Google or Snap, but otherwise don't plan on having that for long, right? Your investors are not going to be happy about having that additional complexity in your company. We do a whole series of presentations on dealing with venture capitalists. And just one thing to keep in mind is simplicity is always a good idea because they're looking at your company with your complex, highly creative, laudably creative cap table. They're trying to figure out, and they're also looking at the glass box next to you. So I'd be careful about it, but sometimes I let founders get away with it if they've got good reasons. Transfer restrictions, I just want to mention this. People kind of gloss over this. This is all the boilerplate, they call it, that they sign without reading or understanding, and that works fine. It's not a problem till it becomes a problem. So generally, even though I see people try to do this, it's really hard to prevent somebody from being able to transfer their stock at all. It's hard to just have an agreement that says you are not allowed to ever transfer your stock. I see people pop it into the bylaws and stuff like that. Good luck enforcing it. You know, who knows? However, you can make it really hard for someone to transfer stock without having an absolute restraint on sale of stock. That's called a right of first refusal. In other words, the way it works, the ROFR, as it's commonly known, is that founder wants to sell shares. They have an obligation to offer their shares to the company. And if the company doesn't want it, then they got to offer them to every investor in the company. That's very burdensome, and a potential buyer is not going to like having to go through this stuff. So just keep that in mind. You have to understand how that process works before you think about getting money on a secondary trade. Now, keep in mind, if you are going to have a right of first refusal, as a founder, you might want to negotiate some carve-outs. For example, you want to be able to transfer your shares to an estate planning trust for the benefit of you and your family. All right, that's pretty standard stuff. You might want to have just a percentage and say, look, I'm allowed to sell X% of my shares to whoever the heck I want to. That's a carve out. You might want to negotiate that so you can get some liquidity down the road. I've got some other things on that that I hope we get to tonight. Lockups, that means that you will agree not to sell any of your shares within 6 months of an IPO because they don't want you dumping your shares into the market, depressing the price. Co-sale rights, that's the idea that if you find a buyer for your shares and you go through the right of first refusal, nobody else wants to buy your shares, but you found some sucker that will, you have to agree to let your investors participate in that sale. They get to sell some shares to your buyer too. That's a co-sale right. Drag along is just the opposite. Your investor finds the sucker who wants to buy the shares, but he doesn't want just the investor shares. He wants your shares too. Drag along says you have to sell them along with if the investor says so. By the way, I hardly ever see these rights exercised. These are things that we negotiate mightily over, but are actually very improbable scenarios. Buy-sell arrangements, we just don't do that in startups. I could tell you why, but a buy-sell means that even your vested shares have to be sold back to the company if you leave. The reason we don't do that is because there's usually not a lot of value in an early stage startup. It's not till they're down the road, and by that time you're going to have lockups, co-sales, ROFRs, etc. And Rule 144, which is the rule that it's a securities law rule that says you can't go out and do your own mini public offering. You can't do a distribution. And that means that you have to hold your shares. I won't go into the technical aspects of this, but generally there's a holding requirement on Rule 144. And if you don't meet it, you're going to have to go get an opinion of counsel that you're allowed to sell those shares. I'm going to jump ahead a little bit here. I know I was going to talk about the cap table. The only point I want to make about the cap table is know what your cap table is. I mean, I see a lot of companies that don't have a cap table, and you should not only have a cap table, you should have a pro forma cap table. You should be figuring out where you are now, where you are in a fully diluted, that means counting that stock option pool of 2 million, and where you are on an issued basis, because it's only the issued shares that vote and only the issued shares that have a right to participate in the proceeds of sale. So you should know those numbers, and you should know where you are in those numbers and who you have to buddy up with in order to get a majority vote to do anything. So you need to do cap tables, and you need to do pro formas, and you should do what ifs on a regular basis. The best entrepreneurs I've ever seen, they just live in these cap tables, understanding where they are. By the way, there are commercial cap table software tools available now that make this real easy. Rarely are complex cap tables right. There's always some number that's off because somebody didn't sign a document someplace, or somebody calculated interest on their convertible note differently than you might, or something, or somebody just signed an agreement that said, you know, it'll take a fewer shares, a few extra, whatever it is. So I like the commercially available. It's kind of like crowdsourcing, or it's like distributed ledger cap tables. Everybody has the same one that they can look at. Let me circle back to that. Now, we're going to get into the investment side of this. I said there were 3 constituencies. I covered the founders. I covered the service providers. I want to talk a little bit about investors now. And let's just kind of cut right to the chase. These days, most early money is coming in under what they call a SAFE, Simple Agreement for Future Equity. They're simple, or they can be. They're simple, and until a lawyer gets a hold of one, and then we start adding stuff and changing the forms. But that's good and that's bad, because the bad part is that it's pretty easy for you to go online and download a form. I would discourage you from doing that, because you might not know what you signed up to. So let me tell you the 2 kinds of safes that are floating around out there. One is the pre-money safe. This is the one that makes sense, okay? This is the one that you should use. This is the one that is company friendly, because there's a cap. What is a cap? And let me explain how a safe works. A safe says, you give me your money today, you the investor, and I'll give you stock tomorrow when I have a preferred stock investor. A big bad VC is going to come in and value this company. And you're going to get the benefit of that valuation, or if it's less, you're going to get in at this lower valuation cap, right? So a low valuation cap means that the investor gets a higher percentage, right? Lower cap, higher percentage. Makes sense. So that's a valuation cap. So if the company's worth, I don't know, maybe $1 million today, and you take the money in and they take your money and they build it into a $50 million company, which I have seen happen. And now the safe converts. If it converts at that $50 million valuation, which is what they used to do, well, then you didn't get very much for your money, did you? You're going to kick yourself for not getting in when it was worth $1 million, letting that founder talk you into waiting until it was worth 50 million until they converted your money. The valuation cap solves that problem. It stops that runaway valuation. It says, look, we're going to treat you as though you converted at a $5 million valuation, or maybe a 10 million, so you're not diluted and beat up too much. So that's a valuation cap. Now, the difference between a pre-money cap and a post-money cap is a pre-money cap is before any other equity, any other money comes into the company. So what we do is we say, look, let's say there's a 4 million pre-money cap. It means that you're going to value this company on a post-money basis at 4 million plus whatever money I give you, plus whatever other money that other safe holders give you, plus whatever option pool you have, because it's fully diluted. So you don't know what you're going to get until conversion, because you don't know how much money is going to be there. You don't know your post-money valuation. Post-money is the pre-money plus the investment money. The post-money valuation solves that problem, or so they say, by saying, look, give me your $1 million now, and I promise you, a 10 million post-money valuation, meaning you're going to get 10% of this company when we do our financing. You're going to get 10% post-money. And that sounds pretty good until you think about it. Well, what if you raise $100 million? You get $10 million worth of stock? What if you raise $1 million? You get 1.1 million? How can there be such a huge disparity between what you're going to get in terms of percentage, right? So the post-money safe, in my opinion, makes no sense at all. So just be careful of that if you're a founder. Let's skip through some of this stuff. I just want to talk about the carve-out plan. I'm going to talk about venture capital terms today. I'm going to talk about the carve-out plan, management incentive plan, we'll call it. So what happens if we just blow it? You've taken all of my advice and still you got to your exit and management is not aligned. We don't have the right amounts of equity in everybody's hands. Somehow it just didn't work out. The best laid plans of mice and men, something doesn't work out, right? That's the management incentive plan. We get to the exit and management, the common stockholders, the founders or the CEO, we go to the VCs, the investors, and say, look, you want us to be happy, right? You want us to help you sell this company. We want us to help you transition and be a team and be on board with this, but we're just not getting enough out of this deal. So what you need to do, VCs, you need to take some of your money and give it to us. You need to take some of the proceeds off the top of this deal and put it into a management incentive plan. So the first X million dollars of this deal gets paid to management. So you can do the right thing by us and we can work real hard to get your company sold. That is a management incentive plan. We see them all the time. Very similar to that is a carve-out plan. That's a share of the sales proceeds. That's when we wait a little further into the process, when we've actually got a deal on the table, and we say, look, we're going to get X million dollars for this sale. X dollars are going to be set aside in a pool, and they're going to get paid to everybody in this company. Now, I do a lot of M&A. Almost every deal has an earnout, almost every one. And an earnout, from my standpoint, it's kind of a lawyer's playground, because there's lots to negotiate and then lots to litigate over after the fact. Sorry, but that's just how they often go, no matter how well they're drafted. But getting back to my point, now we got a carve-out plan. So I'm management, and I'm going to participate in the proceeds of sale as a bonus, but there's an earnout. So not everything is paid on day one. Some of it's paid based on how well the company does in year 2 and year 3, right? That's what an earnout is. It's contingent consideration. If you hit these targets in revenue and EBITDA after we acquire you, then you get additional consideration. I'm going to participate in my percentage of that earnout as well. That typically happens. Now we have to think about this. So what if I leave the company before the earnout or the deferred payment term expires? Do I still get the payment? That's a vesting restriction, right? And if I don't, who does? All the other employees in the pool get it, or do the owners get it? And if it's all the other people in the pool, you got to wonder if incentives are aligned, because there's not really much teamwork there if they want other people to leave. So think hard about these issues, but there are ways to fix this on the back end. You have to think about it. And by the way, plan for it when you form the company. You can actually draft into your organizational documents how this is going to work with your investors if you do get into an earnout situation, which is very likely. We did a whole thing on in re trato shareholder litigation. It was a management incentive plan that everybody got sued. The VCs won at the end of the day, but it was awfully painful for everyone involved. So I'm not going to talk about this. I talked about it last week, but just keep in mind that there is some risk around these if they are not properly handled. There's a right way to put these in place. Otherwise, you might have other common stockholders who are getting nothing, who aren't very happy about your management team getting in Trato $7.8 million. Partnerships, I'm not going to talk about the tax issues around partnerships, given that it's so late. But I am going to tell you that I often form companies as LLCs and then we incorporate them. Not a big deal. There are a couple things I do want to mention. Excuse me. Two things I want to tell you about. We all know about California. We've got a new rule here that not so new anymore, but taxes gig economy workers as employees when they were independent contractors. I've only got 2 minutes left, but I want to leave you with this. That's a tough rule. That's a very tough law for gig economy workers. Very tough law, right? It's caused a lot of people to leave California. I could introduce you to them because employers or contractors or businesses can't afford to pay them if they have to treat them as employees. It's caused people to leave because out-of-state companies are not going to hire California employees. They just won't do it. They'll hire California contractors if such a thing existed, but since they don't under AB5, a lot of times they have to go to Nevada or Arizona or Texas. Here's what I want to tell you about this rule. Joe Biden loves this rule, right? He loves this rule, and he thinks there should be a national federal law, exactly like AB5. And if you think I'm kidding, there is a bill in the Senate that has been introduced even before the election that would make this federal law. I don't think it will pass, but it's there. And the day may come when all of the United States has the California rule on AB5. So just be careful and be aware of that, because misclassification, yeah, it's a tough one. That's a tough one. That is a company killer if you get nailed on misclassification. All right. What else can we talk about? Well, unfortunately, I did not get through all my slides. I had a few other things I wanted to mention, but I see we have lots of questions. So what I would encourage you to do is enter your questions into the Q&A box. And I'll go ahead and take them. Don't put them in the chat box. The chat box is just to tell me if you can hear me or not. Use the Q&A box, and I'm going to stop share. Okay. And okay, stop share. Where the heck is my Q&A box? There we go. Okay, plenty of questions. Question number 1. Do founders return old equity? Are they not reluctant? You're not kidding, they are. That's why you have vesting restrictions. They have no choice if their shares are subject to vesting. They are forced to sell those shares back. In fact, in most well-drafted documents these days, it happens automatically. It's just the unvested shares that they have to return. The vested shares they get to keep. Remember that buy-sell I told you about that nobody uses? That would allow the company to buy the founder's vested shares, but we don't see that in startups very often. Not never, but not very often. All right, hold on a second. I wonder if I get paid for these product placements and endorsements. What is your recommendation for giving shares to employees? What sort of legal challenges may come up? Yeah, a lot of them. Let's break it down. Corporate tax and securities. As a corporate matter, that's not too bad. You just cannot commit corporate waste. In other words, if you're giving shares to employees, it's because they earned it. You have a good corporate reasons for doing that. That's usually pretty easy. It's not often that you just love your employees so much that you just want to give them some of your shares. It's usually because they're your employees and they're doing something for you. Securities. If you're giving shares to employees in exchange for their services, well, that's a securities offering. It has to qualify for an exemption. There is an exemption, happily. The exemption is called Rule 701 federally. In California, it's called 25-1020, that allows you to establish an employee plan, out of which plan you can give shares or options to employees and contractors and individuals for their past, present, or even future services. Okay, but we have to comply with that rule, so be careful. There's a filing requirement, there's a documentation requirement, there might be other sorts of disclosure requirements depending on the size of the pool. Thirdly, and this is the big one, the topper is the tax issues. Now, to grant shares to an employee, that is always 100% of the time taxable. That's taxable income. The value of the share is taxable to that employee. To grant an option is not taxable until they exercise, which, remember what I said, they never do. By the way, those of you with your hands up, go ahead and use the Q&A box for your question. So giving shares to employees can be taxable. That's the problem that we have. Now, remember what I said, to solve that problem, we'll sell the shares to the employee. They don't have any money, you let them pay a promissory note, but they do have to pay that note at some point, or it has to be forgiven, in which case they have a taxable event then. Now, let me give you a practical pointer. You heard it here first, folks, about this. People, I know what you're thinking. You're saying, I'm going to give shares away. My company is not worth anything. I'm going to value it at 0.0000001, right? Like my lawyer told me I could. I'm telling you, people have been getting away with that for many years, saying that the company is not worth anything. And the IRS just doesn't audit that issue. They don't. They have not. Again, part of the transition is Joe Biden has noticed that the IRS collects about $7 for every dollar of enforcement that Congress gives them. They'll collect another $7. That's a pretty good investment. So you're going to probably see increased IRS audit activity over the next 4 years. Okay. I think it's a pretty good bet. And I think that this is an idea that's gaining steam. In fact, our representative, Ro Khanna, just last week introduced a bill in Congress that would mandate a certain percentage of audits. In other words, it would mandate that 95% of all large corporations over $10 billion be audited, and we require that all individuals making more $10 million, 50% of them would be audited. So, and then there's other numbers. We'll quibble about the numbers. Where I'm going with this is that the IRS is going to be looking at what you're doing, and they haven't for the last they haven't since George Bush was president. They just haven't. And from my standpoint, it's almost like a crime spree what companies are getting away with in terms of valuing their companies and giving shares away. And that's going to come to an end. And trust me, I do audits. I've got some going on right now. And not enough people have been audited lately. And it's like we've all forgotten just how bloody painful an audit is with the IRS. So I would be very conservative and cautious on this idea of giving shares to employees, because yes, you can get away with it until you get caught. What's the creator name of the dynamic split model? Well, I mentioned Mike Moyer. I don't think he created it. I think it was Wasserstein or something like that. If it weren't so late, I could remember. But it's Wasser something. Anyway, Harvard Business School lawyer wrote several treatises on it. There's several people have different dynamic split models. The one I was referring to was Mike Moyer's slicing pie. All this money talk feels arbitrary, adversarial, and makes me squeamish. How can I feel better about it? Man, me too. I'm with you. I don't like it at all. Unfortunately, you're going to have to sit down with your co-founders and you're going to have to go through this. And, just get a coach. Get a coach. I'm not even joking about that. Get someone to, practice with you. You're going to have to get good about talking about money, or you're going to get the short end of that stick. And by the way, it's not going to stop with your founders. Just wait till you talk to your angels. You start haggling over your valuation, and then talk to the VCs and start haggling over control and economics. So you're going to have to. Sorry, I don't have a magic bullet for that one. That is a different kind of agency than mine. Which option type between an ISO and an NSO is more favorable, spelled with a U, to the employee if the employee plans to leave the company? Well, I will tell you that the ISO is much more favorable because the employee can exercise that ISO and not get taxed. And if he hangs on for a year after he exercises, 2 years after grant, and then sells the stock, he pays capital gains tax only on the gain from the sale of the stock. No ordinary income component at all in there, plus no FICA FUTA taxes. That's the Social Security Social Security taxes we have here in the US. So an ISO is way more favorable. However, there's AMT, right? There's alternative minimum tax. So it's kind of a cruel joke to say, yeah, no tax on exercise of an ISO, because if you make enough money, if you're a high enough income bracket, you're going to pay alternative minimum tax, and that can be very complex, but also takes away almost all of the benefit of having an ISO. By the way, I'm glad you asked that question, because that reminds me of something I want to tell you about. This is another important takeaway. I'm here in California. My clients are all going to Miami. They're all leaving. I shouldn't say all of them. A lot of them are. A lot of them are coming to me. It used to be every day. Every day I'd get this question. Now it's down at least once a week, and they say, hey, am I going to get taxed on my option if I leave? The answer is relatively complex. It requires some modeling and some spreadsheets. But generally, California is going to tax you on your option based on the relative amount of service you perform as an employee while you have that option. Once you exercise the option, that tax element closes, and then you leave the state, and then you sell, that gain escapes California tax. So this is another place where restricted stock gives you a huge state tax benefit, because you get the stock on day one, you work here for 10 years, you leave, then you sell the stock, you don't pay California tax. Contrast that with an option. You get the option on day one, you work here for 10 years, you leave, you exercise the option, you got California tax. All right, can a granted option be changed from ISO to NSO? Absolutely. Vice versa, very difficult, because it becomes treated as the grant of a new option, and it has to be repriced at current fair market value. So think of it as a ratchet. You can go one way, but not the other. Hey, qualified small business stock, is that a good way to lower the tax rate? I love this, all these tax questions. I'm in hog heaven up here. I love tax questions. It's so rare that somebody loves me for my tax expertise. I seem to remember qualified small business stock as a way to lower the tax rates on both federal and California stock. Is that still around? Yes and no. It is around in a big way for federal purposes. And here's what qualified small business stock is, folks. If you buy stock in a qualified small business, that's generally a business that has less than $50 million of assets, using tax numbers, and a company is in an active trader business. You're not a lawyer like me, they don't like us, but if you're in an active trader business, not a consulting business, that's a qualified small business. Almost every company I work with starts out that way. You buy stock, you pay cash for it, right? Or property or services. And you hold that stock for 5 years, you sell the stock, you can exclude up to 10 times your cost basis, which is probably very little, but maybe not, or $10 million, $10 million, tax-free, $10 million of gain, tax-free, right? It is a holy grail of tax. You've avoided all the tax on the sale of that stock. It is a huge, huge benefit. That's the good news. The bad news is that California doesn't recognize that. So if you're a California resident, you don't get any of that benefit. I would love to talk to you for an hour as to when we had it, when we kind of had it because the courts messed it up and then we didn't have it and why. But I'll just tell you, we don't have it in California. Keep in mind, you got to hold for 5 years. If you sell before that 5 years, you know, you're not out of luck. What you can do is you can sell the stock, roll the proceeds over into another qualified small business within 60 days, and then you don't pay tax. So it's a great deal. Can employee stock options be revoked? No, it's a contract. So it is a contract, and it's whatever the contract says. Now, the contract might say, and they often do, in fact, they always do, if I draft them, is going to say when this company gets acquired, your option is toast. It goes away. You either exercise or the acquirer agrees to cash you out or assume or substitute or something. But at the end of the day, once we're acquired, we don't want to hear from you again under this option plan. So you do need to know what your contract says. Here's an interesting fact for you. It is purely a contract. It's no fiduciary stuff at all. So you really are bound by the words in that contract, even in California. So just be careful about that. So it can't be revoked, but there are ways you can certainly lose it under the contract. If my exit schedule is, I love this guy and this guy's questions. My exit schedule is 7 to 10 years. How can I financially support myself? Well, Top Ramen would be one suggestion. I don't know, do your parents have an extra room for you? Yeah, it's a tough choice because startups don't pay people compensation. They pay you in equity. It's a long time before you get paid. And by long time, I mean until you get funded, until you get an angel or a VC that's willing to cut you a salary. And if you need to live until then, you're going to have to live off your savings or you're going to have to get a part-time job, right? You know what they call a startup entrepreneur in Silicon Valley, right? Hey, waiter. So, you know, you need to get a part-time job or be financially secure. You know, the best way is just to get to that funding event as quickly as you can. With a startup maybe 3 to 4 years old, who has found their product fit with paying customers? Who has found their product fit with paying customers? Is it better off to negotiate to have more ISOs or RSUs? Well, if you're only 3 to 4 years old, I don't think you're going to have an RSU. I just don't think it's appropriate. You know, you want to be closer to liquidity than that. And that's great. You got product market fit. But again, I'm not a big fan of RSUs. What happens to my equity if my startup is bought out? I'm not one of the founders. Will my vested options turn to useless papers? Okay, well, following up on what I just said, you got to read the contract. What is going to happen? I don't want to scare you because what is going to happen is you're going to get a notice from the company that says, hey, we're being acquired and this is what's going to happen to your option. And it'll say one of a few things. It'll either say, we're going to cash it out. You're going to get X dollars at close, sign this release. Or it's going to be assumed, and now your option in my little company, little startup, becomes an option in Microsoft or whoever that's acquiring you. Look, you've got 15 days to come exercise your option, and if you don't, it expires. So you need to read the contract and read the notices that the company gives to you. And all of these plans will give you a notice, you know, before anything happens. I shouldn't say they should. Let me put it that way. All these plans should. That would be the right thing to do. Oh, this is a long question. Holy cow. I started a company to fill a research contract. It's a big contract. Awesome. You've been paid quite a bit of money on it already, outside vendors and advisors. You got a lot more coming. Okay, it's all good so far. But because of the nature of the research contract, I cannot pay employees with options. So I got to pay them in salaries. Okay, well, that's a drag. Any suggestion to apportion options between my shares and the next 4 employees? Yeah, get a hold of my slides and go back to the slide on the guy who did all the data from AngelList on what the next 4 hires are, and use that as a guide, because you're not really apportioning your shares. What you're really doing here is you're diluting yourself by granting additional options or issuing additional shares. So I think that's a good place to start. But again, this is a highly subjective, fact-based, individualized sort of scenario. By the way, you're a sole founder and you got that much money on research. That's really interesting. That's congratulations. I hope your next 4 employees and advisors are people that can complement your company in areas where you might not have your greatest strengths. How are preferred shareholders treated as opposed to common shareholders if the startup IPOs? They're treated just like the common stockholders in that their preferred stock is going to always convert to common, and they're going to get common, they're going to have common stock in the public offering just like the common stockholders. They're not treated like the common stockholders in that they're often always given what they call registration rights, which gives them a couple of things: a right to demand an IPO, a right to piggyback on other IPOs, a right to participate in other offerings. I see so few startup IPOs in my business. I don't know. I want to talk about that a lot. Suffice it to say, they've got more rights until you get to IPO, and then they get common stock. Can you elaborate a little on equity for service providers? Equity for service providers. Well, so this valley was built on equity compensation. I'm going to go back in time, give you a little history lesson since you asked to elaborate. So I'm going to do. This valley was built on equity compensation. There was a time in this valley when people would come in and they'd say, like they do today, I'm a startup. I got very little money, but I got lots of equity, as much as I can print. But I don't want, I want to give it away to my people instead of cash. They're service providers. They're advisors, they're employees, they're this, they're that, they're you. Will you take equity? And there was a time that I would. There was a time when I wanted to and I couldn't because equity was so valuable. Those days are gone. But there was a time when we would grant people options, and the option price would be down here and the stock price would be up here, right? And as long as that spread wasn't too big, the IRS wouldn't notice, right? They call that cheap stock. But that stock price would go up and up and up and up. And our IPO event is over here. Our option price is down here, and the stock price goes up and up and up and up and up and up, and then we IPO up here, and the stock price is down here. The SEC hated that, as did the IRS. That was a cheap stock issue, and they forced companies to put charges on their earnings statements for cheap stock charges because that was an expense. We used to argue about it forever. We fought about this all the time, but there was no real teeth in it till Enron came along, and then Congress added teeth in it about 20 years ago, 15 years ago, 20 years ago. And the teeth is what we call 409A. Now, under 409A, options have to be priced at fair market value. So IPOs over here, startups here, we're about right here in stock price, and new service provider comes along. Well, they can't have a price that's down here. They have to have it at the current stock price. And if they don't, there's a big tax and there's a big penalty. That's why you have to get valuations for your option plan. So that's equity for service providers. There are tax issues all over the place. The corporate stuff is easy. The security side we've got covered, but the tax issues are all over the place. You got to be close to that fair market value or you have a lot of risk. Let's see here. Oh, someone just asked me about 409A and I just answered it. When do we need to do it is the question. You need to do it before you do the option grant, and it's good for a year. Okay, good for a year, unless there's some big event that makes it no longer reliable, like you've done a financing. So keep that in mind. What if the angel wants to opt out, but the money left, but you spent all his money? So he's asking the founder. Um, so he's asking the founder to guarantee that personally. You have no obligation to do that. If you've done everything right, okay. So here's the scenario: company sold some safes, took the safe money, spent it on code and all sorts of very legitimate expenses. You didn't use it on going to Cancun. Um, so the angel says, I changed my mind. I'd like to have my money back. Well, that's not the deal. That's not the deal, angel. The deal is that you're going to leave your money in this company until we have an exit. And the founder is not obligated to give that money back. Now, sometimes I've seen founders guarantee those debts. 2 years ago, I saw a founder lose his house because he guaranteed those debts. Okay. So don't do that. Don't do that. Don't sign a guarantee. But typically, founders won't do that. So it's not going to be that big an issue. So sorry, angel, unless you want to pay him back and keep, good relationship with the angel, but it's a rare founder that would do that. By the way, it's not something I invested in, is it? Because if that's the case, my answer is totally different. Okay, what's the best way to maintain a high degree of employee ownership and employee financial investment in a company while still allowing for VC and other external funding sources? So I think what you're talking about really is control. And that's just a negotiated scenario. So here's some more rules of thumb for you. You and the founding team, you should maintain control of your company even after your Series A round. If you don't have control after your Series A round, it means you did something wrong along the way. You took in too much money at too low a valuation. You will lose control after Series B. You should just plan on that. So plan on being the CEO until Series B, and then they're going to fire you and find somebody else. That's how it oftentimes works. Now, when it doesn't work, I'll tell you why it doesn't work. It's because safes are just so darn easy, and they're so darn easy to go out and download and just do yourself that founders can give away lots and lots of their company in safes without knowing it. Why don't they know it? Remember what I said about the pre-money safe? You don't know how much of your company you've sold because it's pre-money. All you know is your pre-money valuation. You don't know how much stock that investor is going to get until you actually have a close. Then we get to a close and we get the spreadsheets out and we do the numbers. It's like, holy cow, I sold that much of the company for that little money. I've seen deals tank that way. I've seen them completely tank where the institutional investor takes a look at it and says, oh, no, you haven't left enough money there for the founder, because they're going to start asking questions just like the one you just asked. How do I maintain my ownership and allow you, the VC, to come in and provide for runway for additional financing sources? So that's why I say set up a cap table and model it out. Someone asked me my thoughts and perspectives on slicing pie. For the right company, it can work. You got to have the right company and the right set of founders that are willing to have the discipline and be honest enough to do the system. One of my friends raised $500K in a pre-seed round by giving away 30% of the equity. He wants me to come on board as CTO and build a product. He's offering 10% in equity vesting over 4 years and some salary. What pitfalls should I be aware of before signing the papers? Well, okay, I'm going to give you some non-traditional advice. You're making an investment in this company, just like any investor. So you need to do your due diligence. So here's a couple things I would do. If someone offered me that deal, I would do the same diligence an investor would. And if you want to know what diligence that is, pick up a copy of Jason Calacanis's book, Angel, and he'll go through a whole chapter on how to diligence a company. In fact, you should do that anyway, just so you know what to expect when you get smart investors in your company. I would want to diligence the company and see how solid they are. It's pre-seed, it's 500,000. Somebody believed in them, although it was at a very low valuation. Where are they in the market? Have they got a beta? Do they have traction? I'd also, and this is something people don't do enough until you get up into the later stages, is I would diligence the founders and the team. It's very easy to do a background check, especially the litigation side. I want to know if there's any trouble there. I can't tell you how many times that, just trust me. You want to know who you're doing business with if you're going to, if you're gonna come in on something like this. The rest of it, 10% for a CTO investing over 4 years, all sounds pretty standard. Okay. Are stock options only applicable after a priced round? Ah, good question, because that's often what happens is that the options are granted only after a priced round. Now, that doesn't mean they have to be. In the good old days, before we had to get, someone asked me for my email address. I'm going to drop my LinkedIn in here. In the good old days, before we had to get valuations, we used to do option plans right out of the gate. As soon as we started the company is when we would do an option plan. We don't do that anymore. Usually what we say, we give people an offer letter that says, hey, we're going to, there it is. That says, hey, we're going to grant you an option when we get an option plan. We're going to get an option plan as soon as we close a financing. Why is that? Well, for a couple of reasons. The number one reason is because they're expensive, right? And companies, before they get funded, don't want to spend the money getting a valuation done because you have to get a professional valuation. Number two, it's really hard to value a company at an early stage. Let's wait until we get an investor. Then we'll have something more because the investor will have valued the company. We'll have better metrics and we can set a value. So it's not that they're only applicable after a priced round, but it's usually how it works out. And before then, we'll give people an offer letter promising an option grant, or we'll just grant them stock, right? Just a stock grant or maybe a sale of stock. Somebody asked me what book I was referring to. So I'm going to tell you what book that is. I don't know if you can see this or not. Let me see if I can see it. This is the book I was referring to, okay? By the way, here's another great book you should read, my book, Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup. Both of these are available on Amazon, and you can have a copy if you go on Amazon and buy one. Or if you email me, I'll send you an electronic copy. Is it possible to grant ISO options to founders and NSOs to other full-time employees? It's possible, but it's not advisable because for your founders, for people who own that much stock, the ISO has to be granted at 110% of fair market value. And I mean, who wants to pay 110% of fair market value? Plus, if you're a founder, you may be an AMT, I don't know. So it's possible, and sometimes we do that. We'll have stock and ISOs, but usually not. Usually it's just stock. Okay. What else we got here? How are ICOs coming along into the new strategy? Honestly, I have not seen one in a long time. An ICO is an initial coin offering. I used to do a lot of work in that space. I don't anymore. Not because there's anything wrong with them. It's because that business, because of the securities laws, has pretty much gone offshore. So yeah, not so much. ICOs, not so much. Okay, are redemption rights gone? So redemption rights, that's what the VC asked for. We do a whole hour, 2 hours on this, in fact. They'll ask for lots of rights, and some of the rights they'll ask for will be what they call redemption rights. And what that means is that after a certain amount of time, if the company hasn't exited, then the company, if the investor elects, the company has to buy the investor's shares back. Yeah, it's really terrible. And basically, if the investor wants you to buy their shares back, it means because something is really wrong and the company doesn't have the money to buy them back. So it puts the company in a bad situation. You know, we fight back as much as we can against them, but in later rounds, you're going to see that pop up. So are they gone? I don't think they're gone, but I don't see them in early rounds at all, not in early rounds. Later rounds, I still see them pop up, but people are smart now and they've kind of figured out what not to do. All right, how does California compensate employees for lack of qualified small business stock? Oh, I can tell that was asked by somebody who's never been to California. They compensate you with a higher income tax rate. That's how they compensate you. Are there alternative schemes to benefit California employees? The only one I can think of is to move to another state. No, let me tell you, and I'm not California bashing. I've lived here for 30 years. I'm here for a reason, but this is a high tax state. This is an expensive place to do business. However, we do a whole hour on why you should be here. It's called How to Do Business in Silicon Valley. So find it on my YouTube channel if you want to know the reasons why you would pay those high taxes. and live with no qualified small business stock treatment. But no, there is no offset to that. All right. Would you repost your email again? I think I did that, but I'll do it again. Actually, I don't think I did that. Thank you for reminding me. And would you repost your email? On that awesome question, we are at 8:30. I am going to go ahead and conclude the presentation. I want to thank you all for being here. I want to thank you for asking great questions, and I will see you next time.